Can I just say something about Andrea?
I know that we all hoped that saner minds would prevail, but when it comes to Robert Devine, yeah, I'm afraid on some level, we all knew we hadn't seen the last of him. So Robert Devine has appealed Post Commission's decision to decertify him as a law enforcement officer. He has exercised his right to go to the Superior Court and request review of that decision. So I've got the filing here, and we're going to go through it. And let me tell you, it's going to be a lot of fun. And the reason why is because, well, let's just say that we already know Robert Devine, by his own account, is basically an estate planning attorney. I have serious questions about the quality of what he's doing in that regard. But he is definitely not an administrative lawyer. And boy, does it show. Because, yeah, guys, he's representing himself in this process. It was one of the main questions I had, I guess, maybe the hope that I hung my hat on that this case would not go any further was based on whether he'd have to hire an attorney to go and take care of it for him. He had an attorney, of course, throughout the post hearing and the post process, but we saw that Michael Proctor had one, and that was an attorney that was provided to him by the union. And so it was part of his decertification process that after the new text messages came out, the ones that I don't know, they seem to have set off a whole new flurry of issues with Sergeant Good now being on administrative leave and under investigation, so forth. The union attorney, the union dumped Proctor, decided they were no longer going to stand by him. So his decertification has gone through as well. So I'd kind of hoped that maybe they help him through this process, and then after that they're on their own. And if there was going to be cost or friction like that, maybe he wouldn't subject us to another round of what he does, his denial and the Ipsy Dixit, the insisting that things are because he says they are. But can't rule out the idiotic decision to go in and represent himself on an issue in which he is clearly just miles out of his league. So we're going to go ahead and take a look at this judicial complaint that he's prepared. So we can see, look at the plaintiff. It's Robert C. Devine ESQUIRE. I gotta tell you, let's just leave aside the whole how nobody who wants to have any credibility as a lawyer uses the title Esquire. It's so try hard. Like, it's not like they teach you that in law school. You have to kind of ascertain this by having friends and colleagues in the legal community, and the ability to kind of socially pick up on cues and things like that. So just the use of the Esquire already screams like, oh, he's one of those. But I'll tell you why I think it's a particularly bad idea in this case to be calling attention to Esquire. He's a lawyer, guys. He's a lawyer. He's like basically waving his hands, a big flag at the judge saying, look at me, judge, I'm a lawyer. And I don't think that was wise because when you're representing yourself pro se, there's usually law that says, hey, you don't get special treatment as a pro se. You have to follow the same rules and requirements as everybody else. We're not going to cut you any special breaks just because you are choosing to act as your own attorney. But the practical reality of it is that they really do. They really do cut breaks to pro ses because they don't want to deprive people of meaningful access to the courts. And yeah, the reality is lawyers can be quite expensive and it can be very difficult to do that. And so a lot of the times courts will give the benefit of the doubt to pro ses. They will overlook technical problems. They will overlook, bad argumentation and just like look at everything in the best possible light just to give that person a fair shake. But if you're going to go waving your hands going, judge, I'm a lawyer, then I think the judge is probably going to go ahead and hold you to the lawyer standard. And when it comes to Robert Devine, I don't think that's probably a good call on his part. So we'll go ahead and go through his memorandum. So first is just the basic application here. Now, a couple of things we got to call out. Plaintiff's appeal is based on a claim that the defendant's decision was, and now it gives you these options and these check boxes. Check which ones apply. Guess what? Wow, all of them apply. All of them apply. Every single one. It's in violation of constitutional provisions. It's in excess of authority. It's based on an error of law. It's based on unlawful procedure. It's unsupported by substantial evidence. It's unsupported by the record, and it's arbitrary and capricious. And how many times are we going to type in see attached support affidavit? Like every single line we're typing something like that in. Yikes. So, who knew? Who knew that literally everything that could go wrong with an administrative decision has gone wrong for Mr. Devine? Are you shocked? Are you shocked? I'm just blown over, I tell you. I can't believe what a victim this guy has been yet again. He's been victimized in every possible way by the Post Commission. And what does he want? He wants 4 times reinstatement of certification and removal from the registry. I don't know. I don't know what this is. I don't know why he feels the need to fill every single line with his demands. But that's how he has chosen to present this this request that he's making. Now, you will notice, of course, that he also seems to be using a scanner that might date to like 1997 or something. This quality, look at it. You couldn't just go to Staples or something, have it scanned and not be this absolute mess. No, he couldn't. It's going to be entirely covered in these lines, the whole document. So do just be prepared for that. The trash quality of what we're getting here. And there, look at that signature, Robert Devine ESQUIRE, and he makes the point to spell it out in his block letters so that we can see it. We can see it there. Make sure we don't miss that part, the ESQUIRE part. He's awfully proud of that, isn't he? Would be a shame if something were to happen to it. Certifying that he served it by mail to the Massachusetts Post Division, I guess, commission, whatever, send it to them. And now here is his brief, his memorandum. There's going to be a couple points where we're going to stop and look at some law. We're not going to get there quite yet, but we'll get there pretty soon. But we're going to go ahead and let him introduce us to what he's got going on, what this victimization is that he's identified. The hearing officer found that respondent Robert Devine engaged in a pattern of unprofessional police conduct that may escalate, and that he has repeated sustained internal affairs complaints for the same or different offenses. Devine maintains that the initial finding is in violation of constitutional provisions, that his due process rights have been violated. Based upon an error of law, the decision is wholly and completely based on hearsay and cannot be sustained. made upon unlawful procedure, and unsupported by substantial evidence. Okay, so first thing I notice right off the bat, you got these four bullet points here. But you checked 7 of these boxes, 7 boxes, okay? In excess of authority, unsupported by the record, arbitrary and capricious. So are you not actually arguing those? It's really hard to tell because you seem to just like shotgun this this application, but you actually have something else to say in your memorandum. I certainly noticed that right off the bat. I have to expect the judge is going to notice that too, because it's just kind of one of the things that you look at right off of the bat is what are your assignments of error? What are your specific allegations about what the hearing officer did wrong? And so when you are inconsistent in your presentation of what those things are, I might just kind of come to the conclusion that your overall presentation here is likely to be along the lines of a disorganized rant. And so I'm going to be looking for that expectation to be discounted. Let's see what I find. This pleading incorporates by reference the respondent's objection to initial decision. Yeah, we knew he filed an objection to the initial decision. Violation of constitutional provision. Okay. So he's jumped right into, okay, here's his violations that he's arguing. The errors. Violation of constitutional provisions, number 1. So he's jumping straight into his argument about a violation of the constitutional provisions. Normally, what a lawyer will do in a situation like this when you're writing a brief about particularly a review process, is you start with what they call the standard of review. And so I'm going to share with you this statute here. This is what is cited in the hearing officer's decision as like the governing rules for these types of appeals. And so this is laws relating to state officers and the state administrative procedure. And this section in particular is on judicial review. So these are the processes that apply when a person is going to appeal from a state office, or in this case, a certification. So, except insofar as any provision of law expressly precludes judicial review, any person or appointing authority aggrieved by a final decision of any agency in an adjudicatory proceeding, whether such decision is affirmative or negative in form, shall be entitled to judicial review thereof as follows. And so it describes what the process is going to look like, how it unfolds, and then the standards of review shall be those set forth in paragraph 7. Okay, so we'll just kind of scroll through here, see if there's like anything really interesting. Ooh, this part here, section 4. Let's check this out. The agency shall, by way of answer, file in the court the original or certified copy of the record of the proceeding under review. It shall consist of the entire proceedings or such portions thereof as the agency and the parties may stipulate, or a statement of the case agreed to by the agency and the parties. We're talking about a transcript here. The record of the proceedings is generally going to be the transcript, and it's probably also the exhibits and things like that, except that those are already compiled and in the possession of the agency. So we're talking about primarily preparing a transcript, and it's going to be either the entire thing or less of it if they can agree that less of it is appropriate. Do you think Devine seems like the kind of guy who's agreeable to less of it? I don't know. We'll find out. But one of the fun parts of this is that the expense of preparing the record may be assessed as part of the costs in the case. And the court may, regardless of the outcome of the case, assess on anyone unreasonably refusing to stipulate to limit the record for the additional expenses of preparation caused by such refusal. The court may require or permit subsequent corrections or additions to the record when deemed desirable. Someone's going to have to pay for it. Someone's going to have to pay for that transcript. And generally speaking, if you lose the appeal, it's going to be you. It's going to be you. You're going to have to pay. So, one might think under circumstances like that, gosh, it would be in Robert Devine's interest to limit the record. How good has he been at acting in his own interest so far? 5, the review shall be conducted by the court without a jury and shall be confined to the record, except that in cases of alleged irregularities in procedure before the agency not shown in the record, testimony thereon may be taken in the court. So if there is something that went bad off the record, and so it's not part of the transcript, then they will take evidence about that in the review process. But otherwise, all of this is based on what already happened. This is not a new trial. This is not calling new witnesses, sending out new subpoenas, doing new investigation. This is like an appeal from a criminal conviction. We are just looking at what has already been done. And did the agency follow the rules? And is the evidence sufficient to support the conclusions that they reached? They can make application to the court for leave to present additional evidence, but they have to show it's material to the issues and there's a good reason you didn't do it in the administrative process. Then they can do that, but requires kind of a special step on your part to suggest that that is going to be necessary. Okay, here's the part we were looking for. The court may affirm the decision of the agency or remand the matter for further proceedings before the agency, or the court may set aside or modify the decision or compel any action unlawfully withheld or unreasonably delayed if it determines that the substantial rights of any party may have been prejudiced because the agency decision is. And here's those 7. Look at that. Those 7 things that were in those check boxes on that application that he checked. Every single one of these is a problem. Now, a couple of things about the standard here. The substantial rights of any party may have been prejudiced. He's got to show prejudice, not just, look, he didn't put a period at the end of that sentence. That's an error. I can't understand what it means, therefore I'm deprived of due process. No, you got to show that this was outcome determinative, that but for this problem, the hearing officer couldn't have reached the conclusion that he reached. And again, the court shall make the foregoing determinations upon consideration of the entire record or such portions of the record as may be cited. The court shall give due weight to the experience, technical competence, and specialized knowledge of the agency, as well as to the discretionary authority conferred upon it. This is real important because administrative review gets a little bit of a different kind of handling than criminal appeals do. They are very hands-off towards administrative agencies. And the idea behind this is that administrative agencies are specialized, and so they're understood to have more expertise, particularly in the subject area of whatever it is they're administering. So in this case, law enforcement standards and qualifications and, what cops do, how investigations work, all of that types of thing, police activity, than the court does. And so that's different from a court just reviewing another court. The lower court doesn't have any real special expertise. Now, it had the opportunity to personally observe the witnesses and so forth. And so to the extent that it gets deference, it's because it's in a better position to make those types of judgments than the reviewing court is. But it's not because, it's got more expertise at judging than the judges do. With the administrative process, it's quite different. It's quite different. And there is a strong presumption that this agency is specialized to be able to make these types of decisions. And so normally you got to be pretty far outside of that expertise for a court to be making the decision that yeah, you did something wrong, or your call was bad, or it's just so clearly egregious that anybody is going to agree with that. So I thought it would be helpful to take a minute to look at that standard, since Robert Devine didn't bother to tell us what it was. And this is what the court is going to be doing. They're going to be looking at, are any of these standards met? And has he shown that he was prejudiced by them? So let's go back now and dive right in. Shall we dive right in? Let's start. Due process requires the commission must find to prove classification by clear and convincing evidence. Wow, what a banger of a leadoff sentence, isn't it? It's the words are English, but the meaning is incomprehensible. Due process requires the commission must find to prove classification by clear and convincing evidence. I don't know what the hell he's trying to say here. I think he's trying to say that the decertification, the grounds on which a decertification decision is based, has to be based on clear and convincing evidence. But it's I have to interpret this to get there, and that doesn't bode well for how this brief is going to go. Devine's right to due process was violated, as he was not afforded the opportunity to cross-examine the alleged drafter of the Mighty Riggs conversation documents, SB. Mighty Riggs. It's now Mighty Riggs. You know what I think this means? I think he's dictating this. I think this is a voice to text type of program. Because that's not a misspelling. Like, you don't just accidentally spell Marty as mighty. That's I misheard you. And whatever proofreading he did to this brief that did not cause him to correct this shit show of a first sentence, he also overlooked in the case of Mighty Riggs. That's what it looks like to me. Devine has always contested that he was not a participant in this exchange. Lawyers, competent lawyers, don't use all caps in their briefs. It's shouty. You don't get shouty in your brief. Sovsits will do that in their briefs. That will be a thing that they will do. Lawyers don't do that. Like, if you really absolutely must emphasize one of your words, italicize it is best. Bold, you can bold if you just have to. But see, the thing is that you shouldn't be depending on a single word for your emphasis, and certainly not by delivering it in a shouty way. It's the content, the substance of what you present that should be making the emphasis for you. So it's always just a big tell when somebody feels like they have to shout in their brief. It's probably because you don't have much else to try to get the judges on your side, except to try to bully them into accepting your position. Now we have this footnote here. Respondent does not have a transcript of the hearing, therefore referencing is done using dates and times. Well, that's interesting, because we already heard from the rule that I bothered to look at. Did he bother to look at the rule about the arrangements to provide the record? Not sure that he did, because he seems to not have a transcript, and it seems that you need a transcript to be able to, meaningfully make your argument. So maybe he'll get one after the fact, but, to me, this looks like just disorganization. Couldn't be bothered to get the process figured out. I mean, The issue is you do have a time. You got a time limit to file this thing. But there's nothing that says you got to file this whole memorandum right off the bat. You can file a initial statement. Just give them the basics. But see, that requires editing and refinement and clarity, which is going to be very difficult in a situation like this, as you're going to see. And then get the transcript and then just file your supplemental memorandum. Like, there's typically not a problem with a process like that. The judge wants it to be well sourced, well cited. He doesn't want to have to be listening to the tapes for the citations. If I'm the judge, I might just, if he's lucky, the judge will just ignore this entirely and be like, refile whatever you need to file with the transcript citations once the record has been prepared as the rule says it is to be. But if he wasn't like gonna buy the transcript ahead of time, probably not gonna be real happy if he gets those transcript costs assessed against him, huh? So we have that shouty sentence. He's always contesting he was not a participant in this exchange. In Commonwealth v. Troche, it was prejudicial error to deny the defendant a voir dire examination of a witness regarding the authenticity of social media information that might have contributed to the jury's verdict. Okay, I went and looked at this case, and I'm not gonna bring this one up here because it's kind of long. But the first thing that jumps out immediately, of course, Commonwealth v. Troche. This is a criminal case. This is a criminal case. It has a different standard when it comes to due process. Due process is kind of flexible because the court says it really depends on the nature of the right that's at stake, and the process that's afforded just depends on how serious and the risk of erroneous deprivation and things along those lines. So when you're facing the loss of your liberty or potentially your life, that's the most serious thing the government can do to you. But the loss of some administrative certification, it's not nothing. I mean, yeah, you're going to get some process for it, but you don't have like the Fifth Amendment right to confront your witnesses. That's fairly unequivocal, like you do in a criminal case. So, like, we're already a little bit off the rails here because he's trying to import criminal law standards that are very protective of the defendant into his administrative hearing, where his rights are nowhere near this level. But I also looked at this case, and it was like, it's so like factually not on point. It was a situation where you had a state witness who is making an identification of the defendant, and the defendant gets an anonymous text message that's got some screenshots from social media posts that are purporting to be from the state's identification witness that suggest he's lying about the ID. And so there were like a couple layers of problems there. The text message itself was anonymous. There's no provenance for it. It just like shows up out of the blue. They don't have any idea where it's from. And then, the screenshot of the social media, likewise, it's a screenshot. It's not even like a link that you could go and kind of investigate a little bit about. You have no idea if it's been altered or not. So it's kind of different from a situation where we have extractions of data directly from Sandra BIRCHMORE's phones and computers that include her social media activity. And we know from the hearing officer's decision that her accounts were linked with her devices. They had a linked account identification number, an IMEI or whatever, something like that. So it's just, and then the voir dire examination. This is a totally different context about the basis for the person's information and like, are you going to be able to testify or not? This is just so bizarre as a case to kind of put in here, because it's not on point, and it's not even in like the right universe of legal standard cases. Like at least use admin law to talk about your admin standards. But no, he doesn't do that. He's going to do that repeatedly throughout this and cite a bunch of criminal cases where he finds it convenient. The Troche decision cites to Commonwealth versus Purdy for the proposition that evidence that an electronic communication originated from a social networking website that bears a witness's name is not sufficient alone to authenticate the electronic communications haven't been authored or sent by the witness. He's butchered this quotation as well. Again, that's not grammatical English. But it's also not really on point either, is it? Because we don't just have Facebook messages with Sandra BIRCHMORE's name on them. We got them from her computer and from her devices. So it's not just, oh, her name is on it and that's all we have. Not sufficient alone. Okay. But if you got some corroboration, like where you got it from, then it's going to be fine, even under this criminal standard. So fancy that. Robert Devine distorting the law, reading it. I mean, I don't know what he's reading. I really don't. I don't know what he's seeing here, but he thinks, wow, that's going to be really helpful to my case. It's not on point. Devine has been denied his rights to due process under the Article 10 and Article 12 of the Massachusetts Declaration of Rights, which is part of the Massachusetts Constitution. Oh, no shit. I bet the judge didn't know that and is so glad that you put that in there. You could just say he'd been denied his rights under the Massachusetts Constitution pursuant to Article 10 and Article 12, or you could just say Article 10 and Article 12 of the Massachusetts Constitution guarantee Devine rights of due process, including, hey, what are we going to be talking about here? Because due process is a very large concept. So it might help to kind of refine it down to exactly what it is that you mean. These articles ensure that individuals have fair and impartial legal proceedings and protections against government actions that deprive them of life, liberty, or property. No citation there. Weird. That's one that should be like really easy to cite, but no, he just says it. Further, under the 14th Amendment of the United States Constitution, which applies to state governments, also so helpful. No person shall be deprived of life, liberty, or property without due process of law. Due process ensures fairness and protects against arbitrary government actions, including in legal proceedings. Actually, mostly specifically in legal proceedings. That's literally what legal proceedings are, is the due process that you are afforded. Again, no citation for that. Fairly simple proposition to substantiate, as lawyers do, since lawyers know law is not something that we just make up in our heads and say. It's something that exists written down somewhere where we can find it and cite it, and then everybody in the world can go and find it and read it for themselves and see, oh yeah, that is what that says. That is the law. And then they can decide for themselves how that applies to our specific situation. The division produced hearsay evidence with no foundation or witnesses to authenticate it against Devine, who was unable to call or subpoena SB and examine her since she is dead. Devine could not have secured information from SB prior to the hearing using multi-layered hearsay allegedly generated by SB or some unknown person against Devine is a violation of Devine's rights to due process. Again, no citation. The division relied on hearsay that lacked the reliability and probative value necessary for due process. Devine was unable to call SB to rebut the allegation she allegedly made. Therefore, all evidence presented by the division as it relates to the 2022 IA investigation against Devine and as it relates to statements allegedly made by SB or messages such as the Marty Riggs documents were inadmissible and must be stricken as they violate Devine's right to due process. That was a mouthful. That was a mouthful. So it relied on hearsay. Therefore, everything's out. Kind of hard to tell from reading this. So is your problem with the 2022 IA investigation against Devine? You're calling that out specifically. Is that a due process problem? What about it? Hearsay? Is that the issue? Statements allegedly made by SB. Okay, we can understand that there is some level of hearsay here that has to be dealt with. The content of the messages. You were talking about authentication and foundation before authentication, so it's kind of unclear, how that's relating to hearsay here. But I understand the general gist. What Sandra said out of court is hearsay. Now we gotta think back though. Remember, the hearing officer's decision pointed out there's a lower standard in the administrative hearing when it comes to admitting hearsay. It's not prohibited. Administrative hearings don't have to follow the rules of evidence that apply in court. They just have to adopt processes that provide a minimum standard of fairness for due process purposes. So he addressed that specifically in the decision. Might be helpful to challenge like his actual reasoning, point out where the actual reasoning is wrong. But what he's doing here and is going to continue to do throughout this whole thing, and it's going to get far worse, by the way, is just relitigate. He's just relitigating the same thing. He's like representing his closing argument that he already made, that the hearing officer already said, by the way, I don't believe you're lying, ass. You have no credibility. I think these records are fine for the purposes for which they were offered. By the way, I've gone through and worked out my resolution of contradictions between them and inconsistencies and so forth, and reach my conclusions in light of the like he's forgetting about the part where Marty Riggs had things to say. We were at a disadvantage with the hearing officer's decision because we were still having the contents of the communications redacted. But you guys might remember throughout that decision, there were huge sections of the communications, the conversation between Sandra BIRCHMORE and Marty Riggs that he relied on in the opinion. And the idea was that the content of these communications themselves tended to establish that there had been this sexual encounter between Sandra BIRCHMORE and Marty Riggs. And that was then corroborated by statements that she made to others, including Joshua Heel. Also corroborated by his own testimony about, oh yeah, I did go to the Chateau restaurant, did meet up with her there. There's no trees there. No trees there. Not a one. It's wide open. In the meantime, might as well be like in the middle of Windsor Park or something. So we're kind of, we're starting the rant. We're like already into the rant. This is just relitigation. It's not good lawyering. That's not how appeals work. Appeals are technical processes based on the standard, focused on the decision that was made and emphasizing why that decision was wrong. It is not your opportunity to go in and just rehammer on facts that you think matter more. than the ones that that the hearing officer found most persuasive. That is not going to get you anywhere because the hearing officer gets to decide what he thinks is important. And lastly, just these, conclusory, they violate his rights to due process. You could spell that out. I assure you, the judge would find it much more helpful for you to spell out specifically how do these violate your right to due process, because they're just being all kind of lumped together, and all we've heard so far is hearsay. Need to like connect the dots here. Connect the dots here. Tell me how this admitting. Well, first off, show me how it's hearsay at all, and then show me how it's using it in this administrative process, which is allowed, is somehow so problematic that it amounts to a due process violation. This results in the division not sustaining its burden in this matter. It's just kind of a throwaway sentence. The initial decision is based upon error of law. Okay, so we're already moving on here from violation of constitutional provisions. That's it. Okay. All right. I guess that's our argument on due process, because now we're moving on to the error of law here. We don't even know like what aspect of due process was the problem. Due process encompasses things like your right to counsel, your right to cross-examination, your right to notice, your right to present evidence on your own behalf. I mean, all kinds of different facets of adjudication. Which one is the problem here? Why is it a problem? We don't know, but that section of his brief is apparently done. So it's essentially because he says so. It's a due process violation because he says so. The hearsay evidence in this instance was unreliable and not, we have bolds again. Now we have bolds. At least he didn't all cap it. It's a little less shouty. Not the kind of evidence on which reasonable persons are accustomed to rely on in the conduct of serious affairs. With his C cite. His C cite that he's lost a parenthetical there as well as a period. So just gotta notice these things. The acceptance of multi-layered hearsay in this case to support the decision is an error of law. This is just like conclusory assertion piled on conclusory assertion, and we haven't seen any kind of reasoning process. I've said many times that if there's one word that is so helpful to see in your introductory paragraph, preferably sentence, but your introductory paragraph in a section of your brief, the word I need to see is because. I need to see the word because that's what shows me what your reasoning process is. How do you get to this conclusion? I'm not going to just accept this conclusion because it's there and you've put some things in bold font. That's not a legal argument. Bold font is not a legal argument. You don't have to go to law school to know how to put things in bold font. I assure you, plenty of pro se sob sits put things in bold font routinely. Multi-layered hearsay, he hasn't explained what that is or why that applies. He's just using this word multi-layered hearsay. So we'll see if he gets to that. In Commonwealth versus Purdy, again, we're in the criminal case. 4 Mass 492, the issue of the authentication of criminal defendant Duncan Purdy's electronic emails that were used against him at trial was at issue. The SJC found the emails were authenticated and pointed to specific facts to support that decision. The emails originated from an account bearing his name. He acknowledged using the email account. The emails were on a computer that he acknowledged he owned. He supplied all necessary computer passwords. One email contained an attachment with a photograph of Purdy, and in one of the emails, Purdy described himself. We, of course, don't have the full record of Sandra's communications, but we know she communicated with a lot of people, and we know that they interviewed those people about those communications. We know they interviewed Josh Heel. We know they interviewed the Farwells. We know they came from her computer and from her phones. We know that she talked about, herself and other things. She sent like tons and tons of messages. Did she send photographs? I'm willing to bet she probably did. So, I mean, I don't know. I don't know. But they had a massive amount of data from her devices that included these messages that he doesn't like. So, he just says none of the factors set forth in Purdy directly apply in Devine's case. Saying that none of them apply does not mean that none of them apply. I mean, this is like going to be a fairly easy layup for the commission to be like, yeah, here's the ones that apply, and here's why the hearing officer said it was okay. It came from the extraction from her devices as part of the investigation, and they were able to corroborate that these messages came from her by talking to other participants in those communications. None of the factors, they do. Okay, you saying they don't doesn't mean they don't. In fact, they do. Throughout the life of SB, the only records the division claims are communications between SB and Robert Devine are the 2.5 months of communications that are known as the Marty Riggs documents. This was from a Facebook Messenger account. Chief Brian Holmes testified that the person who sets up the Facebook account would send out the first messages. What? That's not what he said. That's not what he said. He talked about how when you set up like a Facebook Messenger account, there aren't going to be like any messages. It doesn't say anything about who necessarily sends the first message. I don't even know where on earth he's getting that from. The first exchange in the Marty Riggs account is SB. She sent out the first 2 messages. Oh, well. Throw it out then. He's already just relitigating what he thinks happened, what he wants us to think happened. And none of this matters. Your argument about what you think happened doesn't matter. What matters here is how the hearing officer got it wrong, how the hearing officer's decision, what he thought was important and what he focused on and he decided, why does that violate the law? And when it comes to his interpretation of the facts, that's a particularly tough standard to meet because you're typically talking about a clearly erroneous type of standard. Like only if it's completely contradicted by the record is his finding of fact going to be a problem. You pointing out other facts isn't getting you anywhere. But hey, she sent out the first 2 messages, and according to what you think Brian Holmes said, that means it couldn't have happened. It's just yet another reason, right? A gazillion reasons why it's impossible and it couldn't have happened. It's not possible. We know there's more. We know there's more. According to Facebook, there were 9 messages recovered, and they are only messages that SB sent. So they did get some information from Facebook, but they only got 9 messages recovered. What does that mean? Does Sandra delete her messages in Facebook? Maybe. I don't know. I really don't. Were these, did she have like backups? Did she back up her Facebook to her laptop or something like that? And that's how they were able to get them? I don't know the details. I mean, this is the first time we're hearing about any information from Facebook. Regarding the contents of the Marty Riggs documents, on November 27, 2020, Devine was waiting for his grandmother to die. Oh, remember this? It couldn't have possibly He couldn't have possibly had that interaction with Sandra because his grandmother was dying. And no way is he the type of complete freaking scumbag who would do something like that while his grandma was dying. Yeah, might as well be impossible. He was waiting for his grandmother to die and spent time with her and his father at a nursing home under COVID restrictions. She died on November 28th, 2020. Given the relationship found between SB and Marty Riggs, if Marty Riggs were Devine, this topic would be part of an exchange between them at Thanksgiving time, but it is not. Devine's bereavement leave to bury his grandmother is never mentioned by Marty Riggs. This is that same terrible, terrible argument that we saw during his closing. There's absolutely no requirement that they have any kind of conversation like this. I know he's heard of a booty call and what that implies. And do you share all the details, the ins and outs of your personal life with your booty call? Is there some rule that says that's how it goes? It's just the reasoning here. It's so illogical. It's just astounding. I don't understand. Just putting aside how pointless this is, because the hearing officer already rejected this. And your job is to show how that was clearly erroneous. And just restating these things when he already said, by the way, dude, you lack credibility. You are not a credible person in any way. It's not getting you there. Putting all that aside, what even is this thought process? It's just mind-boggling. It really is. That somebody would think this is convincing. Oh yeah. They would have had to have talked about that. I mean, people that are married sometimes don't talk about things in their personal lives. Like there's just no necessity for this conversation to have taken place. I don't understand it at all. On January 6, 2021, SB asks Marty Riggs if he was an FTO. The response is no. The Stoughton Police Department uses the term FTO to identify a qualified officer as a field training, officer. It's just terrible with the punctuation. Devine, a former deputy chief of the department, was also a field training officer, which would again exclude him as Marty Riggs. Because he said so? You didn't cite that, by the way. You didn't cite that reference. But you also didn't support it with anything but I said I'm still a field training officer. Am I to take it he didn't lose that ability after he was demoted 3 ranks for his dishonesty and conduct unbecoming? That he was still somebody that they entrusted to teach cops how to be cops? You'll have to forgive me if I'm a little skeptical of that. But of course, it's also not like physically impossible for Marty Riggs to lie. Yeah. Guess what? Those things can be consistent. Those things can be consistent. In Devine's case, there was no opportunity to examine SB and to authenticate the documents. I don't know what this sentence is doing here. This was the same thing he was saying in the first section that he did not explain very well. We know you didn't get to examine SB, but you haven't established why that's a due process violation. The authentication, you're just taking issue with it having, the manner in which they authenticated it. You don't think it was good enough, but you haven't established why. It was extracted from her devices. It was corroborated through, interviews with the subjects of the communications. That's how we know that they were Sandra's communications. Oh, this is a good one. This is a good one. Here's where we're going to look at some cases, guys. The initial decision finds there is a pattern of conduct, but does not set forth specific events, which is an error of law. No citation. No citation. There's no actual law that requires that the decision sets forth specific events, right? Or he would have cited it. So it's an error of law that doesn't exist because it's not cited. But I guess we're taking his word for it. The law seems to be what Robert Devine says the law is. Okay, this gets fun. Proof of a pattern of conduct includes a minimum of 3 incidents. Huh. That could be bad. See Commonwealth v. Bigelow. Oh, it's another criminal case. Well, indeed I will. Let's go ahead and take a look at Commonwealth v. Bigelow. What page did he say? At 561. Let's go ahead and scroll down to page 561 and see what this context is here. 561. What do we have here? Oh, look. This is about what constitutes criminal harassment. This is a case about criminal harassment. In substance, the defense's argument challenges the sufficiency of the evidence. If the evidence of conducts or acts of alleged criminal harassment consists solely of protected speech, the Commonwealth did not and cannot meet its burden of proving the defendant's guilt beyond a reasonable doubt. It's a freaking criminal harassment case. What the hell does that have to do with your decertification hearing? A conviction requires proof that the defendant engaged in a knowing pattern of conduct or speech or series of acts on at least 3 separate occasions. Yeah, because this freaking statute requires that. This statute does. Where is any sort of connection between the criminal harassment statute and the standard to decertify you as a police officer? Where is that in the law? Because this is really, really pulling something out of nowhere here. This is pulling something out of nowhere. Proof of a pattern includes a minimum of 3 incidents. See Bigelow? That's not what it says. It says criminal harassment requires 3 incidents. I'm just, the Esquire, the court is starting to see that and think about that and realize it doesn't belong there. It's what is happening here is not Esquire stuff. I mean, this is just wild. Like that, there's no logic for that standard to apply here, except that he wants it to. He thinks it should because it helps him. So therefore, criminal harassment is the same thing as decertification. The 3 instances must be separate and distinct theories. Commonwealth v. Arias. Oh, okay. Let's take a look at that one too. What page? 433. Commonwealth v. Arias. Let's go to page 433. What do we have here? We know we have another criminal case. Oh, this is an assault case. This is an assault case, and because alternate forms of assault contain different theories, i.e. attempted battery or immediately threatened battery, an assault may be committed in 2 separate, distinct, and unrelated ways. But that claim erroneously elevates the related and overlapping subcategories of a single element into separate theories. The rule laid down in Berry and developed in Acheta does not automatically apply to every alternate method by which a single element may be proved. Rather, it is restricted to cases where the alternative theories presented are substantively distinct or similar. Clear? Totally clear how that applies in Robert Devine's case? Yeah. Yeah. Not to me. Not to me. The issue here is that assault has a lot of different definitions. Assault can be actually hitting somebody, it can be placing somebody in fear that you're about to hit them. The common law, the distinction between them was battery is when you're actually, actually harmed. Assault is when you're placed in fear of an imminent harm. So there's different ways. If these are collapsed in many jurisdictions, they are in Washington. We don't have battery anymore. Everything is just an assault. So you have a lot of different ways of committing an assault. And so if you're going to charge discrete incidents, you can't charge somebody with 2 counts of assault for the same act under 2 different theories. You can charge people for 2 counts of assault based on 2 acts under the same or different theories. But they have to be distinct acts. That's all this is about, is that when you have something like an assault that's defined in multiple ways, if you're going to charge multiple counts, you have to prove different underlying acts. I don't know what the hell this is supposed to have to do with Robert Devine's decertification. It has nothing to do. Look at this. Notice he's suddenly thrown in the Northeast Reporter citation form. he's I haven't pointed this out, but he's very inconsistent throughout this whole thing with his case citations. He doesn't know how to cite cases. Commonwealth v. Bigelow. Okay, so he's got this at cite here. That's not correct. So if you're just citing the Massachusetts Reporter, you cite the volume, the reporter, the first page of the opinion, and then the year. And so the first time you cite a case anywhere in your brief, that's how you cite it. After that, you can use shortened citations. If you were going to use an at cite, you would take out this 554. It would just be 475 Mass at 561. This one is a lot closer to being right, because he's got the year here. But now he's also included the second, the Northeast Reporter, which is a West publication. Some places you include both sites. In Washington, you include both the official and unofficial reporters. He hasn't done that so far anywhere in this. He's only cited the Massachusetts so far, 459 Mass, 442. So he's all over the place. It looks of very sloppy cutting and pasting, which goes hand in hand with the bad voice to text and the lack of proofreading and so forth. The 3 instances must be separate and distinct theories. In this instance, there is at best 2 events which are not similar. So I don't know if you want to concede that there were 2. Isn't that your whole point? There's not 2. But at best, there's 2, and 2 is enough. Okay, you've provided nothing. We accept your proposition that this would not establish criminal harassment. And so to the extent anybody thought about charging you with criminal harassment out of this, we concede that is not legally substantiated. That can't be done. But no basis whatsoever that decertification requires three strikes. Cops get 3 strikes. That's your argument. Where's the basis for that? There's none. This is ridiculous. Which are not similar. They both involve dishonesty. They both involved conduct unbecoming. They both involved your shitty I was hacked excuse and cover up. I kind of think they were pretty similar. Furthermore, the only 2 people who testified for the division were Chief Donna McNamara and Chief Brian Holmes. Both testified to multi-layered hearsay. Again, what are you talking about? Identify the layers, please. Both testified to multi-layered hearsay. Devine objected to the admission of the 2022 IA report at the hearing. Okay. Why was that wrong? Why was it wrong to consider the 2022 IA report? Here's his footnote. Let's go down to his footnote. The 2022 IA report with its exhibits encompasses all evidence submitted by the division related to the Marty Riggs documents. Okay. You objected to it. Great. And your objection was overruled. Why was that an error? That's your job. You as a lawyer should know in this review process is not to tell him what happened, but tell him why it was wrong. Because he doesn't really care that you objected. He cares if the commissioner's handling of your objection was incorrect. But you haven't shown him why that's the case. You haven't even really made it clear what we're talking about here. Just multi-layered hearsay. A decision of a board that rests entirely upon hearsay evidence cannot be sustained. See Moran versus School of Littleton. This case is also cited in an ABCC decision against Paga Inc. DBA Icon from April 9, 2024 as a reaffirmation of findings based solely on hearsay. I don't know what a reaffirmation of findings based solely on hearsay is supposed to mean. I don't know what that's supposed to mean. A decision of a board that rests entirely upon hearsay evidence cannot be sustained. All right. Let's talk right now about hearsay and what is hearsay and what isn't, because this comes up a lot. We know the basic rule. You guys already know the basic rule. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. But there's a lot of exceptions to hearsay. And one of the big exceptions to hearsay is the statement of a party opponent. So commissioner offering Robert Devine's statement is not hearsay. Robert Devine offering the commission's statement, not hearsay. Offering your own statement is. So hearsay can be a very flexible concept depending on what it is that you're talking about and what it's being offered to prove. Now, the Marty Riggs texts, the whole point of them is that they are Robert Devine's statements. That's what the court has found. The commissioner found, yeah, you're Robert Devine. How do we know that? Because of the things they themselves say about when you were admitted to the bar, about, you know, the other circumstances that were going on, the meeting up at the chateau and so forth. The fact that your bullshit excuses, nobody bought. They were ridiculous. They were so ridiculous. They're like basically consciousness of guilt. Like, how do you make up something that's stupid if you're not just guilty as hell? So that's not entirely on hearsay. He based his decision in significant part on the things that Marty Riggs said in those texts. And he concluded that Marty Riggs is Robert Devine based also on non-hearsay evidence about things like, what was his date of admission to the bar? Were there any other Roberts? Did he work the same shift? So even if we accept this rule does not apply. This is just a guy who, can't be honest about any detail. He's got to just universalize everything. It's all this or it's all that. He won't recognize, because that's too hard of an argument to beat. That, okay, yeah, part of this might have been hearsay. The things that Sandra said might have been hearsay. But other stuff wasn't. Because that's a harder argument to make. You don't get to rely on this universal standard here. And you also have to show, how does that prejudice you? Take Sandra's statements, take them out of the picture to the extent they're offered for the truth of the matter asserted, and just rely on what Marty Riggs had to say. Because if you, Mr. Devine, are Marty Riggs, and we find you are, then it's not hearsay. It's a statement of a party opponent. That's why he can't make an honest argument, because he doesn't win if he engages honestly, and he's got to win. So he's got to pretend the facts are something other than they are, and the law is something other than it is. And it's so blatantly transparent. In the present case, the post-commission is a new entity, and one must find comparable entities for argument. He's just saying there's no case law yet, specifically dealing with the post standards. You can just say, here's why the standard applies. You can just say there's no case law yet on the post standard, but here's this other one, and here's why it applies. The ABCC adheres to MGL Chapter 30A, Section 11, adjudicatory proceedings, additional requirements. 2, unless otherwise provided by law, agencies need not observe the rules of evidence observed by courts, but shall observe the rules of privilege recognized by law. Evidence may be admitted and given probative effect only if it is the kind of evidence on which reasonable persons are accustomed to rely in the conduct of serious affairs. Agencies may exclude unduly repetitious evidence, whether offered on direct examination or cross-examination of witnesses. More bold. He must be right because it's in bold. Yeah, look at that. Agencies need not observe the rules of evidence observed by courts. They had a lot more flexibility in what they get to consider, as long as they think it's reliable. So, investigative reports, are they reliable? Well, we didn't look at that original decision that he cited up at the top, the Troche. I think it was the Troche. No, it was the other one. It was, let's just go all the way back up. Basco v. Matchin. We didn't look at that case. That one was a revocation of somebody's Section 8 benefits. And it was based on police investigating complaints about somebody being present at a Section 8 house. And Section 8 defines like new residents as somebody who's present on the premises for 15 days or more, or 30 days in a, I think, 12-month period. And it creates a presumption that if those facts are established, that the person lives there, and if an unauthorized person lives there, then there's a violation of the Section 8. So the police report was fine in that case. Relying on the police report was fine. What was not fine was that the contents of the police report didn't establish facts from which that conclusion could be drawn. They just established that people were present there. So the kind of evidence that reasonable people are accustomed to rely on, that can include things like investigative reports. That can include things like phone extractions, laptop extractions, records of your schedule, and so forth. And it's on you to show why it doesn't meet that standard. And just saying multi-layered hearsay over and over and over again isn't going to get you there. Not without breaking it down and establishing what is hearsay, why it doesn't fall within an exception, and why it is inherently unreliable. While the post-commission adheres to 555 CMR 1.10 4B evidence, post-commission rules for introduction of evidence, we have more really sloppy cutting and pasting. 1, the rules of evidence observed by the court shall not apply to hearings held under 555 CMR 1.10, but the rules of privilege recognized by law shall be observed. 2, evidence may be admitted and given probative effect only if it is the kind of evidence on which reasonable persons are accustomed to rely in the conduct of serious affairs. Bold again. The presiding officer may exclude irrelevant, unreliable, and repetitive evidence. As one can see, the standards of evidence are identical. Thereby, one should apply the same case law, including Moran and Paga. That's not exactly how it works, but you did find the most pompous possible way to make this argument that the reasoning from these cases applies equally to the post-commission because the standards are the same. So the court's interpretation of how that standard is applied should follow into the context of the post-commission hearing. The facts set forth in the August 2022 IA report cannot be sustained as a matter of law. Therefore, there is only one event to consider, the 2015 IA investigation. That is a single event that does not support a finding of a pattern of conduct. How did we just get here? How did we get from talking about these standards to the facts set forth in the August 2022 IA report cannot be sustained as a matter of law? How on earth did we just get there? You have skipped over an awful lot of steps here in establishing that the facts set forth in the August 2022 IA report are not the kind of evidence on which reasonable persons are accustomed to rely on in the conduct of serious affairs. And I suspect that's because I don't think you have a very good read on what normal people think is reasonable, Mr. Esquire. No, why? No, because. You notice you haven't seen. Have we read a single because in this brief yet? I don't think we have. I don't think we've seen a one. Not a single because. No reasoning here. The because is I'm saying this. I'm saying this. You got to buy it. I don't know why we're supposed to reach this conclusion. He hasn't given us any basis for that. Unlawful procedure. Okay, we're now moving on to the third bullet point. We are now apparently done with the violation of the rules. Is that what it was? I'm already lost on our bullet points and where we're going. Based upon an error of law. Okay, so we've already finished. He said due process a bunch of times. He said multi-layered hearsay a bunch of times. We're now about to move on to unlawful procedure. Well, let's see what that could possibly be. Now, what I can tell you that typically means is that rule that we looked at, right? This rule about here's the process. It means you did something wrong in here. One of these things that you were required to do, you didn't do. That's normally what unlawful procedure is going to mean. Who knows what Mr. Devine thinks it means? He certainly doesn't tell us straight in here, like, where are the rules of procedure? Which rules? Which procedures? We know that they adopt regulations for these types of proceedings. So which of the regulations have been violated? You already went to the trouble of explaining that to us, right? Because you cited us to them, the CMR over here. So we know that they have regulations. What are the procedures? I don't think he's going to tell us. The respondent reiterates that his rights to due process were violated as set forth above. We know that. We know that. You've said that a couple times now. That the hearing officers, here we are again with this non-English, that the hearing officers engaged in unlawful procedure via the consideration of information not in evidence or misinterpretation of information that was in evidence. Oh, Oh, misinterpretation is supposed to be an unlawful procedure. Why don't you show us where there is a legal procedure relating to the interpretation of evidence? Because I'm pretty willing to bet it's going to be that same old thing in the case law where the hearing officer is the fact finder, and the fact finder gets to resolve disputed issues of fact, gets to make determinations of credibility, and so forth. And unless those findings are clearly erroneous, are going to be upheld on appeal. So he's already telling us in this broken English sentence here, relitigating the facts. That's all he's going to do. You might as well just tell the judge, go ahead and stop reading right here, because I'm just going to be arguing about why he got it wrong, and I'm not going to tell you anything at all about the legal standard or how it applies, because that wouldn't actually benefit me. Like, I wouldn't win if we had to do that. So I'm going to skip over that part. I'm going to make you do all that work and try to sort out what the procedure is. If I'm the judge here, I might just say he hasn't, like, all you got to do is be like, he hasn't pointed to any legal authority for the relief, the errors that he's alleged, and I don't need to consider it any further. The judge does not have to do your homework for you, particularly if you're going to be waving your Esquire flag. Judge, look at me, judge, I'm a lawyer. If you're a lawyer, you better fucking act like one. And this is not that. This is not that. The hearing officer considered materials outside the scope of evidence presented. For example, the hearing officer wrote and considered at footnote 14, according to Apple's website, an application can be hidden from a user's purchase history in just a few steps. Hide purchases from the App Store, Apple support. I remember that. I remember that because my first instinct to that was like, ew. And then a lot of you left comments about how, Andrea, there's actually quite a few good reasons why people might want to have that. A really good reason in there was, somebody might need to be like fleeing a domestic violence situation and need to hide apps for reasons like that. Or they might be in an oppressive government where, you can be imprisoned and tortured because you've downloaded an app or you're part of a chat group or something like that. Excellent points, people. I completely take those to heart. You guys are right. My gut instinct was wrong. It's just part of the context, we're dealing with creepy behavior, and so that's kind of what's on my mind. But yes, we remember that footnote. The hearing officer went and looked it up for himself. Hey, check this out. Check this out. This information was never presented as evidence at the hearing, and contradictory evidence was available. Oh, was it? Was it? You're just saying so. You haven't offered it. You haven't moved to take evidence. Remember what the rule said. Remember what the rule said. If application is made to the court for leave to present additional evidence, and it is shown to the satisfaction of the court that the additional evidence is material to the issues of the case and that there was a good reason for failure to present it, the court may order that it may be taken. You can make a motion to the court to say, court, you need to take additional evidence on this issue because I didn't present it below because I didn't have notice the hearing officer was going to be relying on it. It wasn't part of the litigation before him. So that's going to be good cause to not have presented your contradictory information before. But the judge is not going to take your word for it that there is contradictory evidence just because you say so. You have a duty as a lawyer to follow the processes. And so if you want him to consider something that's not in the record, you need to file your motion, ask him to do it, and show him why. I encourage you to use the word because in your explanation. There are no timeframes setting forth when certain Apple options were made available or how they can be used. So what? He's just suggesting that when he made his screenshots, does he not remember that the hearing officer also found there were problems with this evidence, period? The fact that they were self-produced, the fact that there were contradictions between different versions that he presented. That was in the hearing officer's decision. The mere fact that he had this footnote in here from the Apple Store, not sure that's going to clear the materiality bar. Either for, we need to get this in as new evidence, or to show prejudice. Oh, but for this footnote, the hearing officer wouldn't have ruled the way he did. Yeah, I don't think so. I think you can go ahead and throw this one out, and it doesn't matter. He didn't buy your explanation. There were a lot of reasons why he thought not convincing evidence that he couldn't be Marty Riggs because he didn't have Facebook Messenger on his personal cell phone. We don't know if he communicated through Facebook, and we don't know if he had a freaking burner phone. Is that somehow now impossible? Is it only impossible to send your Facebook message booty calls from your personal phone when your grandmother's not dying? That's the rules of the universe, according to Robert Devine. Nobody buys that. So this is a big, who cares? Who cares? This is a nitpicky thing. All right, maybe he shouldn't have done that. It doesn't matter. It doesn't matter. At page 25, the hearing officer wrote, although he claimed to have concerns with SB approaching his patrol vehicle, repeatedly asking personal questions and making inappropriate and sexual propositions to him, he never recorded or reported those incidents to the proper channels. However, there was no testimony regarding what procedures, policy, or channels, if any, were in place to make such a report. Well, who's that on, Mr. Devine? Who's that on? This was your testimony. This was your testimony in which this came out. You had the opportunity to explain why you didn't, but you didn't do that, did you? So he's allowed to draw inferences against you based on what you choose to say and choose not to say. So you didn't report it, and you chose not to offer an explanation for why you didn't. And now you're going to try to turn around and blame that on the hearing officer? No, that's on you. This decision is not based on facts and evidence. Once again, even if the judge was like, okay, that's an error, this is not a game changer. None of this overcomes the basic problem of what Marty Riggs said that makes it clear he's Robert Devine. And once it's clear that Marty Riggs is Robert Devine, then you got problems from the contents of what Marty Riggs is saying to Sandra BIRCHMORE, and you got problems with Robert Devine staying under oath during this investigation that he never messaged with Sandra, because he did as Marty Riggs. In footnote 9, the hearing officer wrote, it is difficult to determine whether the journal is a complete collection of SB's documents as it was provided by counsel for her estate. The pages come from several documents, including apparent journal entries, personal correspondence, draft correspondence, entries in notebooks, photographs, receipts, and assorted mail. There are no pages dated during the time period of the SB Mighty Riggs conversations. Once again, pretty sure the hearing officer didn't say Mighty Riggs. Pretty sure this is that bad voice to text. This statement is incorrect. The first 3 pages of the journal say, congratulations, we are parents, 2021. There is an ultrasound dated 1/19/2021. Are those part of the journal? Congrats, we are parents, 2021. Okay, when was that written? Where does it say that page is dated during the time period? Where does it say that the ultrasound was part of her journal? I don't see that any of this is wrong. The Marty Riggs documents begin on 11/25/2020 and end on 2/1/2021, thereby encompassing the entire alleged relationship between Marty Riggs and SB. Shall I say it again? Who cares? Who cares? This is immaterial. It doesn't matter. Take it out. Take it out. It doesn't matter. It doesn't affect the bottom line here. This is just nitpicking. I'm going to be right. I got to be right. I got to be right. I got to be right about everything, even if it doesn't even matter. And that's because he knows on the big picture level where it really counts, he's not right. Because if he was, he could cite the law and make the proper argument to show it. The hearing officer considered evidence which was not in the record or otherwise misread some of the evidence which is an unlawful procedure. Says who? Says who? A violation of Devine's rights to due process? Misinterpreting, meaning he saw it differently than the bullshit you tried to spin it as, is a violation of your due process rights? Yeah, I kind of think not. Kind of think not. No citation for any of this. And demonstrates a lack of substantial evidence to support the decision. Only if you ignore that fundamental issue, the whole basis for the decision. What Marty Riggs said. Not hearsay. Not if he's you. And they found he's you. And they're not buying your little shit argument that just because he passed the bar the same day as you did and he met up with Sandra at the chateau the same time that you did and worked the same schedule that you did and met with Sandra and continued. Where she obviously would have known if you weren't Robert Devine, because she's known you for 10 years. She would have known if this was like some catfish pretending to be you. Did you forget about all that stuff in the hearing officer's decision, or you just didn't read it because you didn't like it? So you're just pretending it doesn't exist? If we ignore all that, then yeah, I suppose that issue with the footnote about the hiding the Apple apps means there's no substantial evidence to support. But like, what planet is this guy on? He's got absolutely no theory of mind for other human beings. And this is such a narcissist tell. Just the inability to put yourself in the mind of another person, to see things the way another person sees them. And I think that's why he's got such problems with this reasonable person standard. You know what a reasonable person would rely on? He can't process that. He just has to say, "Oh, no, you know, the IA report doesn't meet that standard." He can't explain why, because he doesn't actually know what a reasonable person is or how they would think. I don't know how he thinks this is going to work. So far, if this is a piece of legal writing for a legal writing class, it's getting a D. Okay. It's barely passing because it's got some law in there. It's got, albeit thoroughly unpersuasive, it has some kind of structure to it. But it needs some real substantial rewrites. It is missing the basic point. Did he not learn IRAC? Did he not learn IRAC? IRAC is the very basic method of legal writing that's presented in law school. Issue, rule, analysis, conclusion. IRAC. Issue. What is the issue we have to decide? Is there a lack of substantial evidence? State the rule. What is substantial evidence? And how do we know if that standard has been met or not? Analysis. Now apply that standard to our facts and show me why. Use some becauses in there to help me understand why I'm reaching this conclusion. And then go ahead and state what the conclusion is. Therefore, based on what you've just told me, it doesn't meet substantial evidence. This is first year law school stuff. Learning how to write, you're learning how to use the IRAC method. Can't see that any of that has ever stuck. It's definitely not what he's doing here. He's just ranting. We're about to enter the "sir, this is a Wendy's" stage of this decision, this memorandum here. Because what he actually thinks lack of substantial evidence means is, I'm going to argue with you again about the facts. I'm gonna point out the stuff that I think matters. It's you know, he's very me-centered, can't get out of his own frame of reference. And so he doesn't appreciate that lack of substantial evidence is a formal legal thing. There is substantial evidence to support a finding when there is anything in the record that allows the hearing officer to reach that conclusion. If the hearing officer chooses to believe it, either directly or by inference, then substantial evidence supports the finding. So you got a real tough burden in an appeal if you're arguing lack of substantial evidence. And that's why he never states the rule, because the rule would be really, really bad for him if we were to apply it. So it's not what he's going to do. He is just going to argue what he thinks the hearing officer should have said. And okay, but that ain't going to get you anywhere. The initial decision does not contain admissible evidence that a reasonable mind might accept as adequate to support a conclusion. I don't know what that means or why you're telling me that, but if that's the standard, cite it. That would be helpful. Devine has challenged the sufficiency of the evidence against him. No fucking shit. No shit. You don't have to tell me that. You're arguing the point. You don't have to tell me you're arguing the point that you're arguing. It says right here, lack of substantial evidence. It's said in the top. We know that. The main piece of evidence against Devine is now it's Mary Riggs. Now it's Mary Riggs. The Mary Riggs document. The hearing officer has taken the position that someone, a police officer who did not testify, downloaded information from SB's phone, and therefore it is admissible. There was no testimony as to how the downloads were performed. The documents are multi-layer hearsay. There was no evidence as to whether the downloads were stored by a network or internet server. There was no evidence as to the chain of custody of the data and whether the analysis stage has altered data. There was no evidence as to the reliability of the documents. Okay, we're going to pause right here because I don't know if any of this was even challenged. I don't know if they even challenged the Sandra BIRCHMORE extractions, let alone what the basis for that was, or, you know, why the hearing officer would have said it's fine. On its face, doesn't seem like the kind of thing that is inherently unreliable, that in the lower, we don't have to follow the rules of court standard that applies to the administrative hearings, why it wouldn't satisfy that. So not sure that these objections have really been preserved. I don't know. The hearing officer adopted as true the Marty Riggs documents, the authentication of which was even questioned by the investigating officer. Was it? You could cite there. You could cite, and then he could go back and check and see, but you didn't do that. Is he supposed to just take your word for it? Is he supposed to just take your word for it? There appears to be evidence of manipulation and or corruption of evidence by the investigating authority. There are alleged exchanges between William Farwell and SB about Rob on 8/16/2020. The exchanges are identical in part, but the exchanges are in reverse order with different times and were presented without explanation. This manipulation goes to the reliability of all. Now we're underlining. Now we're underlining. We've all caps, we've bolded. Now we're underlying all of the computer evidence presented by the division in the 2021-2022 investigation. Why would it do that? Why would these not simply be different formats for presenting the same evidence, the same data? We know that there's different tools for being able to parse the data in an extraction. Are these simply from different tools? Are these simply different reports from the same tool? You can do that as well. You can have it produce information in different formats depending on the kind of report you're asking it to produce. So I'm not seeing any inherent problem here, nor does it seem that this was ever litigated to the hearing officer, at least nothing that we ever saw. We didn't see why this is a problem. He's not asking to present evidence outside of the record of manipulation or corruption. He's just arguing for a different interpretation that the hearing officer rejected. The hearing officer concluded, don't think there's a real problem here. So you got to show why that's legally wrong, or you're kind of shit out of luck here. It doesn't matter. When drafting the 2022 Internal Affairs Report, Chief Brian Holmes urged the authentication of the Marty Riggs documents. Deputy Chief Holmes wrote at page 59, I recommend that we request of the Post Commission ahead of Post holding a hearing that Post file a subpoena for Facebook records to authenticate Marty Riggs as Robert Devine and take any other action within the scope of Post authority. Okay, and we already know the hearing officer didn't like that they didn't do that, but he also didn't find that to be fatal. Further calling into question all the authentication of evidence in an investigation from which he should have withdrawn. Let's just go ahead and throw that in there. That would go to due process. Why didn't, if you're going to bitch about Holmes and his alleged bias, that would be a due process issue. But you didn't talk about any of that in your whole first section. You just kind of lumped the things together about hearsay and, can't find me Marty Riggs. But he's just gonna throw that in here now, load up this sentence. Then Deputy Chief Holmes wrote, I recommend that this entire document be sent to consultants or experts in the field of forensic statement analysis for an analytical assessment of transcripts to gauge the truthfulness of the responses of Robert Devine, as well as the statements that were made to the MSP by William and Matthew Farwell, as compared to this document and all of the evidence that has been submitted in this case. The objective of this recommendation is to obtain or ascertain in a collegial manner an opinion as to the foregoing. Forensic statement analysis to go to truthfulness. This is not going to be a thing. This is not going to be a thing. The statements are on their face contradictory or not. Somebody's opinion that somebody is being untruthful, that's the kind of thing that is not admissible evidence, that is not reliable, and that it doesn't matter anyway, because it's up for the fact finder to decide. Somebody else's opinion is not particularly helpful in making that determination if it's something that they can make their own decision about. Can you decide for yourself if you think Marty Riggs is really Robert Devine and Robert Devine is therefore lying about Marty Riggs? Yeah, we can do that by looking at what Marty Riggs says about himself and the way he describes himself as Robert Devine and the way that Sandra calls him Rob. He hasn't even touched the username. I was hoping we'd get the username. Remember, it was there in the hearing officer's finding, but it's blacked out. It's blacked out. Hot cop Rob, whatever it was, something stupid. However, the investigators got Facebook information on or about July 4th, 2022, before the IA report was finalized. The document produced during the hearing documents at least a partial response from Facebook. According to Facebook, there were 9 messages recovered, and they are only messages that SB sent. SB even had a second phone in her possession that was processed by the police. However, none of this information was included in the IA report, though given the date in July 2022, it would have been available before the submission of the IA report on August 29, 2022. This information was withheld from the respondent until the 3rd day of the hearing, and the phone was never able to be examined. The state police with whom Stoughton police were working made a request to Facebook, but none of that information was provided to respondent, even though it only took a day or 2 to get the information. I don't know what any of this means. This is a beef about process. So it seems to me like this belongs in your unlawful procedure section, if that's what you're trying to say this is. This has nothing to do with substantial evidence or not. This is just you complaining about the handling of Facebook information, which is incomprehensible to us because you didn't deal with this with the hearing examiner. Did you ask him for a continuance to be able to examine the phone? No, I don't think you did. So once again, this is just kind of you playing victim over things you had control over. If you're saying this was late produced and I didn't have enough time, we already know there was an issue with stuff being late produced and that you would need time. And they gave time to do that. And if you had said, we need more time because there's more that we need to do, you probably would have gotten that. And if you hadn't, then you'd be back to having a decent argument about process or due process or unlawful procedure or something like that, that you didn't have a fair opportunity to be able to respond to the evidence that was used against you. But you didn't do any of that. So I don't know what any of this is even supposed to mean. There was Facebook, but no Facebook, and now we have just this one. Oh my God, this sentence. Unauthenticated, multi-layered hearsay is not the kind of evidence on which reasonable persons are accustomed to rely on in the conduct of serious affairs. He has yet to tell us what the hell multi-layered hearsay is, let alone specifically what evidence are you challenging? Stop just using this characterization because you seem to just want to apply it to everything. All of the evidence against you is multi-layered hearsay. I mean, if I'm getting that correctly, because he's like using it interchangeably with all kinds of different things, the Marty Riggs text, the Sandra's text, the IA report, like what the hell are you talking about? And then if you're saying it's not the kind of evidence on which reasonable persons are accustomed to rely in the conduct of serious affairs, and that's supposed to be a legal conclusion, you haven't shown me any kind of legal analysis to get me there. What is the kind of evidence? How do we make that determination? What are the standards that apply to it? What are some of the things that are considered in reaching that decision? There's case law on that. Pro tip from a lawyer to an esquire, there's law on that. And that's the purpose of your brief here, is to show the judge what the law is so that you can use that law to make an argument instead of just saying it and expecting that the judge is going to take your word for it because you put esquire at the end of your name there. This is not going to go well for you. Go ahead and mark that prediction. This is not going to go well for him. The hearing officer did not consider that nearly every person who came into contact with SB commented on her lack of truthfulness or fabrication of stories. The true pattern of conduct in this case is SB pattern of untruthfulness. Now we're going to get to the sir, this is Wendy's. Okay, we're going to get the rant. We're going to get the rant about SB. And everything he thinks the hearing officer should have found that he didn't. Why? Because Contrary to his conclusion here that the hearing officer didn't consider that, the hearing officer actually said the record is quite clear that she was vulnerable. Sandra was very vulnerable and she was easily influenced by these guys. She looked up to them and they took advantage of her. The hearing officer found she was vulnerable. So, yeah, she manufactured stories about others when communicating with, now we're going to get like all the details of the communications, of course, not his, not that stupid username, but all the things she said to other people. When communicating with Billy Farwell, she claimed she had intercourse with a Josh. The understanding is that that person is Joshua Heel, a former Stoughton animal control officer whose interview was then conducted. Oh, like in order to corroborate who she, that communications were happening with Sandra. But they asked him about that, didn't they? So as to authenticate her messages. While Heel acknowledged oral sex with SB, Heel denied that he had intercourse with her. Oh, so we have to take Heel's word for it. The hearing officer said he didn't find Heel was very credible. So Sandra's lying because Heel says something different to try to minimize his own complicity, his own responsibility. In SB's alleged exchange with Joshua Heel, she acknowledged that she and Heel fooled around but never had intercourse. Thus, SB lied to Billy about having intercourse with Heel. Heel made it clear in his interview that SB told lies on a regular basis. Quote, she told lies all the time. Well, if Heel said so, then it must be true, huh? Heel also sent a message by SB on October 5, 2020, claiming she was pregnant. However, in the Marty Riggs documents, SB claims she just learned she was 3.5 weeks pregnant on December 28, 2020. Is it not possible she thought she was pregnant before? Is that impossible in the way that, having sex while your grandma's dying is impossible? Or are those kind of like similar levels there? SB documented having sexual encounters with William Farwell in his cruiser. There is no such credible or reliable documentation to support the conclusion that Devine ever had a sexual encounter with her. Oh, so because she was honest about Billy Farwell, that she's a liar? It's like you can just kind of tune out because this is not going anywhere. This is a rant, sir. This is a Wendy's. SB demonstrated an intent to fabricate stories to place people in jeopardy as early as 2018. At the time, she threatened to commit suicide and put the blame on someone else, William Kilroy. She threatened to ruin his chances of becoming a police officer. She randomly showed up at places and harassed him. I don't see that she actually did that, did she? I don't see that she did commit suicide and put the blame on this guy. I don't see that did happen. So contemplating doing something bad is not the same as doing it, is it? SB claims she went to Devine's home with a dispatcher friend. The dispatcher was identified as Brett Kavanaugh, and his interview was conducted by the Stoughton Police Department. There's a lot loaded in that sentence because she never said Brett Kavanaugh. They decided it was Brett Kavanaugh. Do we know Brett Kavanaugh is the only dispatcher? Do we know this couldn't have been somebody else? Do we know she couldn't have been mistaken about the person's role? I don't know. At his interview, Kavanaugh was shown evidence that SB claimed to go to Devine's house with him. Kavanaugh stated that he did not socialize with Devine and never went to Devine's house either with or without SB. Kavanaugh described SB as somewhat erratic. Yeah, like kind of vulnerable. Also, at times, she would ask him about specific calls she saw while driving around town. Kavanaugh, who knew SB since high school, does that mean cars, specific cars she saw while driving around town? And this is just your terrible Massachusetts. Sorry, guys. Your terrible accent on the voice recognition. specific cows. That was bad. I know. Sorry about that. I think that's it's supposed to be cars, I think. Kavanaugh, who knew SB since high school, eventually had to block SB on multiple platforms. Oh no. Oh no. That must mean there's a lot of reasons why you block people. Kavanaugh also stated that SB was the type that would tell stories and that SB tended to embellish most of what she said. Well, embellishing isn't the same as fabricating, isn't it? It's, elaborating, blowing things up, dramatizing, dramatic license, perhaps. Andrea Wasoka was a special education teacher at the O'Donnell Middle School where Devine used to work in an after-school program. She reconnected with SB when she was about 21 or 22 years old through social media. Ms. Wasoka said that SB would lie, although she would not intentionally start with a lie, and that SB often gravitated towards the dramatic. Tyler Stollmeyer was SB's Dartmouth College roommate from 2019 to 2020. Stollmeyer used to drive around with SB all day long. He stated that SB was an alcoholic, talked a lot, and they did a whole lot of driving around, and that's pretty much all we did. Who cares? They spoke about her childhood in the Police Explorers program. They were so close that SB even spoke with him about having an abortion while in college. He does not recall Devine's name ever being mentioned. Once again, this impossible to have a booty call without talking about your personal life and sharing it with everybody. Like this is just so illogical. There's no consistent line of reasoning here that can be followed through any of these elaborations that people are providing. He just wants an excuse to talk shit about Sandra. That's all he's doing. They drove around all the time. Who fucking cares? What does that have to do with anything? Stollmeyer was shown text messages that he allegedly wrote. He denied writing them. Yeah, because he might not have a reason to do that. Certainly everybody knows everybody else in this investigation has just been completely honest and upstanding from the outset. Even SB's second cousin, Angelique Pirozzi, commented that SB's not telling the National Guard that she had an asthma condition was an indication of her lack of honesty. Somebody who wants to get into the military and has a disqualifying condition, yeah, it's not uncommon that you're gonna cover that up. That's really not unheard of. Stoughton Police Sergeant Roger Hardy knew SB from the O'Donnell Middle School. He was in the schools for 12 to 15 years. Hardy was Devine's supervisor on the 4 to 12 shift. He never had a problem with Devine responding to calls in a timely fashion. Jesus freaking Christ. The self-serving little flattery in here that he's just got to include. He's supposed to be writing paragraphs that prove Sandra's a liar, because therefore, in his mind, that means it's wrong for the hearing officer to rely on her, even though the hearing officer gets to decide for himself who he believes and who he doesn't. So this whole undertaking is just an exercise in, making yourself feel better. But he can't even do that without taking the opportunity to pump himself up here. Look what a good guy I am. He never had a problem with me responding to calls in a timely fashion. It's nothing to fucking do with anything, but he thinks it makes him look good. So he's just going to throw that in there. Oh, well, if he's the kind of guy who responded to calls in a timely fashion, then I guess he should always be allowed to be a cop. That's the most important consideration of all. Ridiculous. He stated about SB that if you saw her out, if you walked into a Dunkin' Donuts, McDonald's or something, and she saw you, she wasn't just going to sit there. She's going to come up and talk to you. This is consistent with what Devine was saying and is found by the hearing officer. So it has nothing to do with Sandra being a liar. It has to do with her being vulnerable and her having this fascination, this looking up to police officers and wanting to engage with them and wanting to have relationships with them that you took advantage of. I think that is what the hearing officer found. Not sure this is the case you want to be making. Oh, now let's get back to the hacking. The hacking that the hearing officer found was ridiculous. What did he say? Curiously lined up well with his need for an explanation for messages back in 2015, just as it did in this later period in 2020. It wasn't so curious, but it was very nice of the hearing officer to say so. Devine deactivated his Facebook account in 2014 after it was getting attacked. He reactivated it in 2016, but it started getting attacked again, so he deleted it permanently. He has not had a Facebook account since and never had a Facebook Messenger account app. Devine even provided his entire phone application history to show he never had the Messenger app. Devine even allowed the prosecuting attorney the opportunity to examine the contents of his phone during the hearing. Devine denies that he communicated with SB using social media and that he is not Marty Riggs. You didn't phrase that correctly. If he denied that he's not Marty Riggs, that means he's saying he is. So he can't even like put care into his use of language to get it right. None of this matters. We already know this is your bullshit story. And the hearing officer said, you're not credible and this is stupid and nobody buys it. And you just repeating it does not mean the judge is going to turn on a dime and decide, oh, I think that too. Therefore, I'm going to overrule this hearing officer. That's not what the freaking standard is. That's not how any of this works. This is just relitigation, and this is just a waste of the judge's time because he doesn't care. He already knows this was your bullshit story. He is not going to revisit the hearing officer's decision that you lacked credibility. Hacking and harassment were the reasons Devine gave for not having a Facebook account, not as a claim that he was hacked by SB. It is clear from the record that Devine was complaining to Facebook about fake accounts in his name and false messages being sent to friends in 2018, well before SB ever mentioned a Rob in 2019 or 2020. I don't know what that even means. We know that your stupid excuse about the hacking came up during your first IA problem when you were lying about the affair you were having with the person that you got the restraining order against while you were still sleeping with them, and then didn't mention that to the police who were arresting her and searching her house and stuff. Yeah, we remember. We remember that. And that excuse worked so well for you then that you decided to go ahead and try it again? Go for a repeat? I don't know what this even means. I don't think anybody was ever suggesting he was hacked by Sandra. I don't even know what this is doing here. The hearing officer certainly didn't make that finding. So I don't even know what this is for. Exhibit page number 1510 was submitted to Holmes as part of the IA investigation, but was not made a part of his IA report. What the hell does that mean? Do the judge's work for him. You think he's going to take the time to go and look through and find exhibit page number 1510? He's probably not. Tell him what the frick it is. What does this have to do with anything? I don't even know. What was this, like a stupid Facebook report thing that he did to try to CYA back in 2014? Wouldn't surprise me. SB had access to Stoughton police scheduling through Brian Kavanaugh and William Farwell. So now you're saying she set you up as Marty Riggs. We're back to that one that the judge didn't buy. SB at times would ask Kavanaugh about specific calls. Is this again cars she saw driving around town and about who was working? The general public also has access to the general police log to see who was working. He's the one who said that. That was from him. And the hearing officer seemed to be like, really? Because that seems like that's probably a bit of an OPSEC issue. If I could just walk right up to the desk, get all of the shift assignments. I got a grudge against a police officer and I can just go find where he is. Yeah, I don't think so. William Farwell and Matthew Farwell had access to scheduling in 2020. SB had easy access to scheduling information. With that said, she did not know specific personal details about Devine, such as how many children he had or when his grandmother died. Got it, guys. We're back in this realm of like certain things had to have been communicated or none of it could have happened. If any of you have any idea of how this logic works, I would love it if you would share it with me, because I consider myself a reasonably intelligent person, but I can't follow this one. I have no idea what this is supposed to prove. It proves nothing except Devine has come up with this very gaslighty explanation for why none of this could be true. That doesn't make any sense to anybody but him. SB kept a personal journal. It documents portions of her life from as early as 8/13/15 and as late as 1/19/21. SB wrote letters to people that were never delivered. In her journal, SB questions her own honesty. She wrote random letters, some to Billy, some to Matt, some to whom it may concern, to Failure Free Right, and some to Babe. She wrote a letter putting herself in the position of an unborn child, signed Your Future Child. She even wrote a suicide note. She appears to play the game Hangman by herself. It documents her having sexual relations with Billy in a cruiser. Times that can be identified in the journal encompass the time the name Rob first appeared in exchanges and end on February 1st, 2021. Robert Devine, however, is never mentioned in the journal. Rob is in the journal between 2019 and 2021, but not Robert Devine. Therefore, it's not him. I just don't get this guy. I really don't. I really don't. The hearing officer specifically said the other police officer named Robert goes by Bob or Bobby. You're the one that goes by Rob. It's you. He found that it's you. And you just insisting it can't be you because she didn't use your full freaking name is ridiculous. In your journal, this isn't a prenup, dude. This is a journal. Most people are going to be a little informal in their journals. I'm going to just need a citation to the rule that you can't be talking about somebody in your journal if you only use a shortened version of their name and not their full legal name. because I'm not buying that. And I've really lost track of where this argument is going anyway. This is just kind of starting to ramble on and on into different things. Okay, she kept a journal and the journal had these different things in it. What the hell does that have to do with anything? We're so far beyond what the purpose of this brief is, the legal standard that's there to be met, how you show the hearing officer didn't meet it. We're already like well out of the universe of presenting a legal argument here. But now I don't even know what freaking story you're trying to tell me. This is just all over the place. This is like he just flipped through the transcript and just, randomly selected stuff that either he thinks makes her look bad or makes him look good, and just put it in his brief for a reason that I can't quite figure out, because it's not a legal reason. Excluding the Marty Riggs documents, which the division claims in a pseudonym used by Devine, which is actually what the hearing officer found. And so you might want to address that. You won't, because it makes it hard to win. But he did actually find that you're Robert Devine. You should maybe talk about what his reason was and why that's legally erroneous, if that's your beef with all of this, which it really should be, because that's kind of at the heart of the whole problem that you're having here with your certification. The fact that you use this burner account to engage in conduct unbecoming and then lied about it in the subsequent investigation. Pretty central, pretty material to the issue. So you might want to address that head on, but you're not going to, because it's too hard an argument to make. And you're not smart enough to pull that off. Excluding the Marty Riggs documents, which the division claims is a pseudonym used by Devine, it was agreed that there are more than 50,000 pages of messages made by SB, and none of them are communications between SB and Devine. So what? It doesn't matter. The ones that were with you are the ones that matter. And you're noticeably not engaging with any of that or addressing that. I see what you've done. I see the part where you've ignored what the hearing officer actually found, and you're just trying to like shout over him. Yeah, it's not how it works. That might be how it works in Copland, shout people down until they comply. That's not how it works in a courtroom, Mr. Devine, and you are going to learn. Claim of intercourse with Rob. Well, now we have this whole new section. We're going to have to drop the D grade now to like D-, because he did have it structured and organized, where he's got his assignments of error are like topically broken up into these sections. But now he's got this completely new section out of nowhere, not an assignment of error. It's just this thing that's thrown in here, standalone, claim of intercourse with Rob. SB wrote that Rob has been in her DMs again. She then claims to have had sex with Rob once and never again, but described it two very different and mutually exclusive ways. Guys, this is going to be gross. If you want to put your hands in your ears, I don't blame you at all. Check back in like 30 seconds when we get through this particularly gross part. On 3/19/20, SB claims facts in the only sexual encounter with a Rob include they had unprotected sex, Rob ejaculated on her, Rob lasted kind of long. On August 14/16, 2020, SB claims facts in the only sexual encounter with a Rob include Rob used a condom, Rob pulled out and ejaculated into the condom, and Rob was quick. Gross. Gross. Like literally nobody wants to know. Holmes testified and agreed that these were two different versions of the same event. If all the hearing officer had to rely on was what Sandra said in these texts, these I believe were with Josh Heel. He doesn't say specifically here, but I believe this was with Josh Heel. It might have been with Billy Farwell. If these were the only reasons they had to believe that she had a sexual relationship with Robert Devine, then there might be a point to any of this. But none of this is what the hearing officer relied on. The hearing officer relied on the Marty Riggs messages, what Marty Riggs said in those messages, what they said to each other in those messages, the way that they at least implicitly referenced a previous sexual relationship, and the way that as the messages themselves played out, indicated that little hookup at the chateau was happening. So none of this is integral to his decision. It doesn't matter. He can't address the stuff that actually matters because he can't win that argument. So he's got to try to bring up all of this stuff that doesn't matter. When describing the event, SB stated that his kid was in bed and she wasn't home and I went to his house. Knowing Devine, Holmes testified that Devine had 2 children. His son's name is Stephen. Holmes testified that there are no phone records that support the arrangement for SB to go to Devine's house. Devine testified that he has 2 children. His son stayed with them from 2001, but moved out after buying a condo at the end of 2021 or beginning of 2022. In about March 2020 through August 2020, Devine lived in his home with his wife, 2 children, and 2 German Shepherd dogs. It was not a quiet house, Devine testified. SB has never been to his home, nor had she ever been invited to his home. Anything that Devine testified to is super not relevant here because the hearing officer said, you're not credible. You're not credible. He discounted your testimony. He doesn't trust any of it. So the fact that you said so isn't persuasive. The hearing officer gets to make that decision after watching you testify and thinking, that's a smug sack of shit. Trying to feed me all these ridiculous stories and expecting me to just swallow them because he says so. Yeah, that ain't going to happen. And he gets to make that decision. And you got a really, really high bar to clear if you're going to convince this judge. That decision on your credibility isn't entitled to pretty much total deference under the law. In fact, I'm really not sure you can meet that burden at all. You'd have to meet the clearly erroneous standard, not about credibility generally, but about some fact finding specifically. And when you are deliberately not addressing what he based his decision on, but talking about everything else in the record that he didn't base his decision on, it's not going to happen. At all relevant times, there were at least 3 other Roberts that had been with the department. Let's throw these guys under the bus. Robert Welch, retired, Robert Letendre, it's a French name, and a Robert Kuhn, now a lawyer. He's the one that went by Bobby, huh? And he was admitted to the bar on a different date? That guy, that one that came up at the hearing? Additionally, at least 3 other law enforcement agencies have jurisdiction in the town of Stoughton: the Massachusetts State Police, the MBTA Transit Police, and the Massachusetts Environmental Police. Yeah, I'll bet she was confused. I bet she was confused about that. Somebody like Sandra, who was kind of obsessed with law enforcement, had been part of the Stoughton Police Explorers program. Yeah, she probably doesn't know anything about the different jurisdictions, different agencies. Wouldn't know who's who. Come on. The hearing officer looked at several exchanges between William Billy Farwell, and his quotations like, this thing is just so sloppy. This thing is just so sloppy. It's like you could just tell the judge, like right at the top, I don't care enough about any of this to present you with an edited, neatly formatted document that's easy for you to read. I'm just going to give you this crap, just like you did the hearing officer. The arrogance here, you're going to swallow it because this is what I have to give you. The hearing officer looked at several exchanges between William Billy Farwell and Joshua Heel to suggest a relationship existed between SB and Devine. He states that Heel provided testimony the transcript does not reflect and oath being given. I don't know what that means. What I remember the hearing officer saying is that the Marty Riggs messages and the conversation about what transpired between Sandra and Rob was corroborated by what she told Joshua Heel. So I don't know what any of this means. Further, the IA report found him not credible. That doesn't matter. Joshua Heel wasn't a witness before the hearing officer for him to find credible one way or the other. The point was the content of their messages. That doesn't require any kind of interpretation of whether Joshua Heel is telling the truth or not. The messages are what they are. And he's got them and he looked at them. The hearing officer cites to the following exchanges. Okay, well, this is stuff that if this is in the hearing, these are parts of things that we did not get to see because it was all redacted, but now it's not. July 10, 2019, unknown individual for police car who's 896. SB Rob Devine. Argument. Now, we got a new format introduced. We're going to just have this thing and then an argument. Following exchanges. We don't know why any of this matters at all. Argument. This exchange is allegedly between SB and some unknown party. SB's first response to car 896 on exhibit page 548 is, today, no idea. There's more than usual because of a funeral. Her second response to car 896 is a guess, Rob Devine. Okay. What does any of this mean? So she was actually messaging about you back in 2019. But somehow you can't be Rob that's in her journal because she didn't say Rob Devine in her journal. August 6, 2019. SB, apparently someone said something about me in the station, that they talked to me or something, and whoever said it, he overheard it, and he's not telling me who it was, and the only two guys that I've fucking spoken to is Billy and Josh. Unknown individual. I wonder who it is. SB, supposedly it was a coworker, so I really don't fucking know, and he's accusing me of lying. SB, he refuses to tell me if it was a Facebook message or a text message. SB, I just don't know. I'm assuming it's probably a Facebook message. Unknown individual. Oh, true. SB, that's the only thing I can think. SB, Rob Devine, question mark, question mark. Still talking about him back in 2019. And now somebody said something about me, or he overheard. I don't know which one is supposed to be Rob. Argument. If the entire exchange is read, it shows the person is not Devine. SB guesses that the person might be Matt Gatta. The person providing the information will not disclose if it is a Facebook message or a text message. They next guess at Rob Devine. SB responds, I can't see that though. She then guesses Kim Leiden. Literally, it could be anyone. Then it's determined that the person is a male dispatcher at the PD who SB graduated with. That's who it was. Holmes testified that the person in the exchange with SB appeared to be dispatcher Kavanaugh, a witness in the case. This exchange actually eliminates Devine as a person who is trying to get with SB. So not only is the hearing officer accepting hearsay evidence, but it's from an anonymous person. The exchange starting on August 6, 2019 is about someone other than Robert Devine. Devine has acknowledged knowing SB, but other than referencing Rob Devine as a name in this instance, this exchange is exculpatory for Devine. I don't know what any of this means or what it's about. I don't know who the theys are and the he and the coworker and who overheard what. I don't have any idea how this is supposed to fit in. So I don't know. I don't even know why this matters. I really don't. I don't know why the hearing officer brought this up because I don't know the context of it. Is this just to rebut The idea that, oh, it couldn't be Robert Devine because she wasn't even talking about me back in 2019. Here she is. No idea. No idea why any of this matters. He's not bothering to tell us that in his magnum opus here. August 25th, 2019. SB, I've heard from B and C and Rob Devine, but not A and didn't tell D and E. Argument. This is a continuation of the previous exchange. While SB has designated letters for some people, there is none for Rob Devine, showing they are not close. What? I don't know why she's using letters for some people and not. How do you know that? I thought you didn't know her at all. I don't get it. I don't why am I supposed to infer that her using your name means you weren't close? Oh, good Lord. SB is glad to have codes. While Devine denies any contact, even if believed, this exchange does not demonstrate that Devine communicated via Facebook or Messenger. It is silent as to the form of communication. Holmes testified that Devine's lack of having a code eliminates him from this. Holmes testified that he found no information that showed Devine had ever responded to SB as stated in this exchange. Don't know what any of this means or why it matters. September 29, 2019. SB, I'm going to Rob's TN. SB, like Devine. SB, I'm going to his house TN. Assuming that means tonight. Argument. This is the exchange brought to the attention of Officer Kavanaugh in his interview. SB writes that she drinking with one of our dispatchers I went to school with and a few of their friends. The person in the exchange with SB was unknown at the hearing. So not only is the hearing officer accepting hearsay evidence, but it is from an anonymous person. Kavanaugh did not socialize with Devine and never went Devine's house either with or without SB. Holmes testified that there are no phone records that support the arrangement for SB to go to Devine's house. There are no records of communication showing SB ever going to Devine's house. This is the kind of evidence, bold, on which reasonable persons are accustomed to rely on in the conduct of serious affairs. We don't know who's talking. This does not support a claim that Devine held a Facebook account in 2019. I don't know if it does or doesn't because I don't have the context for this, and there's just nothing really being explained here. There's just things being sort of thrown out, and here's why it's wrong, but there's no explanation of why any of this matters. January 20th, 2020. SB, so don't say anything, but one of your other coworkers wants to get with me. Billy Farwell. Who's the other one? SB, Rob. Argument. Chief Holmes testified that Joshua Heel was trying to have a threesome with SB, and William Farwell was trying to get SB to send him video of SB having sex with other men and share it with him. Oh, classy. Billy Farwell was encouraging SB to have sex with people and take videos of it. Yeah, that's literally what you just said, and it's the same thing that you just quoted. I get it. You thought that was so juicy, you had to say it twice. The way that they were exploiting her, you think that's really making you look super good in this? Billy Farwell and Joshua Heel sent emails to SB asking about her sexual encounters and pressing for details. So as not to disappoint, SB made things up. Heel believes that SB told him she had sex with Devine one time. The claim that there was ever a sexual encounter between SB and Devine prior to the allegations in the Marty Riggs documents is debunked by SB providing two mutually excluding versions of the alleged event as discussed above. The hearing officer addressed this. The hearing officer said the contents of the Marty Riggs texts themselves imply a previous sexual encounter that corroborates, if he's Devine, what she said to Josh Heel. So once again, he's just ignoring what the hearing officer actually found and trying to dig up all of the things that are collateral. This is his theory of events. The hearing officer rejected it. He is here just asserting it again. pounding the table, thinks if he shouts it down and just doesn't stop saying it, that what, eventually people will just give in and accept. Wouldn't surprise me. Wouldn't surprise me if that's his approach and his attitude. But it's not a legal argument. March 3rd, 2020, Billy Farwell. Anyone else from the department? SB, nope, I've had some try. Billy Farwell, gotta tell me, LOL. SB, Rob's been trying pretty hard lately. SB, it's been 3 of you from there, though. There's this footnote here. Exhibit page 601 contains a photo of male genitalia. Chief Holmes does not attribute the photo to Devine. While they looked for it, Holmes could not find an exchange to show Devine had sent SB the photo. Yeah, I remember that. I remember that pic. Where was that? Where was that footnote from here? Oh, this does not support a claim that Devine had a Facebook account in 2019. This is the one about going to Rob's. Oh, going to Rob's tonight. So it must have been related to this communication with the unknown person. She must have shared it or something. I don't know. I don't know. Billy Farwell, 3. Billy Farwell, me, Matt, SB, and Josh I've done things with. Argument. This exchange does not even discuss Devine having a sexual relationship with SB. The exchange confirms that SB had sexual relations with only Josh Heel, Matt Farwell, and William Billy Farwell. However, again, the division offered no evidence that Devine had any direct communication with SB. While they looked for it, Holmes could find no evidence to show Devine sent messages to SB. Well, they found the Marty Riggs messages, didn't they? It's not like nobody has ever heard of a burner, specifically not law enforcement. In the same exchange, SB claims that she almost had intercourse with Rob 3 months ago, then changes the time frame, writing it might have happened over a year ago. Again, this misrepresentation of fact cannot support a finding against Devine because she wasn't sure about the time frame. Makes it a misrepresentation of fact. I mean, if you applied this guy's standard of a misrepresentation of fact to his own, wiggling around in his stories, I sure wonder how that would work for him. If read completely, the exchange of March 3, 2020 demonstrates Billy encouraging SB to give him a sex story. When reviewing this exchange at the hearing, Chief Holmes testified that Joshua Heel was trying to have a threesome with SB, while William Farwell was trying to get SB to send him videos of SB having sex with other men and share it with him. Billy Farwell was looking for a sex story, and on March 19, 2020, SB gives it to him. This is your theory, dude. But that doesn't make it a fact, and that doesn't make it an error for the hearing officer not to see things that way. Rant continues. March 19, 2020. SB, so Rob was in my DMs again. Billy Farwell, good. Farwell, might as well give it a go then and see if it's any good. SB, I can tell you it's not. Farwell, wait, you did it recently in the last 2.5 weeks. SB, he H me up, hit me up. His kid was in bed and she wasn't home, went to his house. He hugged me, touched me. I sucked dick and he fucked. Lovely. So this corroborates what she told the unknown person, doesn't it? About going to his house. I don't know about the time frame, but she doesn't say it was in the last 2.5 weeks. I don't know, but it's the same general story. She went to his house. Kid was home. Argument. Devine denies ever having a sexual relationship with SB. Yeah, and nobody gives a shit because nobody finds you credible, including the hearing officer. So this is just so. This is like getting painful. This is getting painful. It's so bad. It's so bad. As previously discussed, this claim of a sexual encounter was debunked by SB's own exchanges of what happened set forth on 8/14/2020 and 8/16/2020. Compare exhibits. Okay. Further, the sex story was passed on to Heel by SB on 4/1/2020, only after she created it for Billy Farwell on 3/19/2020. Okay, so she told the story multiple times and to multiple people, more or less the same, other than like the details about the, in-out part. Ugh, ugh, ugh. So gross. Again, Chief Holmes testified that Joshua Heel was trying to have the blah, 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 blah. Yeah, we know about the videos and all that. Holmes testified that as of 4/1/2020, SB wanted nothing to do with Rob. Well, I don't know that he's in any position to know that. He's going by what she said, right? March 19th, might as well give it a go. She says, I can tell you it's not any good. Holmes can testify about what's in the messages. That's it. He doesn't know anything about her state of mind. The name Devine was not mentioned in the exchange. There it is again. It can't be Rob because it doesn't say Rob Devine. It's only ever him if you use his full legal name. I bet if you said Rob Devine, it wouldn't be him either because you didn't say Robert. I mean, this guy can't be serious. He can't be serious. I know he is. He really thinks this is. He really thinks this is the thing, and it's wild to see somebody so out of touch, just laying it on the line. How completely clueless they are about how normal human beings think, because it's not this. May 14th, 2020. The judge's eyes have glazed over because none of this matters. He's been like, okay, he's just relitigating, scroll. I seriously doubt he even reads through all of this. And like, honestly, for his sake, I hope he doesn't, because it is just like gross and not even to the point, SB, like I didn't even make it to the ER before Matt was texting me back. Rob was hitting me up on Messenger and others were texting me. Argument. This is an exchange between Josh Heel and SB. The division has no evidence to support the claim that Devine had a messenger exchange with SB on or around this date or at any time before the claimed Marty Riggs exchanges. SB stated that she had text messages going back to 2017 and also wrote, I don't delete anything. Yeah, but you said she's a liar, so which is it? Which is it? She's totally believable or she's not believable. I can't keep track. Does it just depend on what's convenient for you, Mr. Devine? I kind of think it does. Chief Holmes testified the IA investigation produced no records that Devine reached out to SB through Facebook, Messenger, or otherwise. But we also know they didn't go to Facebook, and whenever they did get to Facebook, it sounds like they just went for Sandra's messages. I don't know that they tried to do anything with respect to the Marty Riggs. August 14, 2020. SB, someone else was in my DMs too lately. Billy Farwell. Who? SB, Rob. Billy Farwell. Didn't he fuck you? SB, once with a condom. I hate condoms. And never again. SB, yes, I've done things with one other person. Billy Farwell. Who? Just one? SB, Josh. And yes, Billy Farwell. Oh, God, guys. Ugh. Come in you, SB. No, down my throat, but he could have, and it would have been fine. He didn't because we were in his office. Laughed my ass off. Gross. Argument. This is the exchange that discredits the one on March 19, 2020. Further, SB had text messages going back to 2017. SB wrote, I don't delete anything. Yeah, we already know that. The IA investigation produced no records that Devine reached out to SB through Facebook Messenger or otherwise. Yeah, we know that's your argument. The exchanges considered by the hearing officer contradict themselves and set forth a theme that Joshua Heel and William Farwell are looking for erotic dialogue, which they then get. Because the name Rob is mentioned, Devine is grouped with these deviants. Yeah, they are deviants, aren't they? And yeah, you are grouped with them. Because we know you're Rob. We know you're Rob. This exchange, when considered with the others, simply do not support the conclusion that Devine had a sexual encounter with SB. They show that SB was a liar looking to please her partners. But I thought she said she wrote she don't delete anything. And she's obviously being very truthful about that, right? So really want to have it both ways, aren't you? I want to have it every way, as long as it's the way that means that you win. And I got to tell you, none of this is it. None of this is it. Had the hearing officer considered all of the above factors, which he did not, he might have reached a different result. Thus, the erroneous exclusion of relevant evidence is reversible error. All fucking over the place right here. This is not the standard. Oh, had the hearing officer just decided things the way that I wanted him to, he might have reached, he would have reached a different decision. So the fact that he didn't should tell you something. He had all of this evidence, okay? He had all of this evidence. So it's not that he didn't consider it. It's that he considered it and ruled against you. And your inability to accept that and come to terms with that and deal with it head on is why you are going to lose this appeal. But then the erroneous exclusion of relevant evidence, where the hell did that come from? What are we talking about that was relevant and that was excluded erroneously? We haven't heard a single thing about something that he wanted to present that he wasn't allowed to. So what the hell is he even talking about? The erroneous exclusion of relevant evidence is reversible error? I'm I don't even know what to make of this. Like, these are words that sound legalish, but there's just no thought process behind this that is anything like legal reasoning. This is just insistence using a certain script, using a certain vocabulary. This really does read a lot. It really does read a lot like those SovSit kind of briefs, where it's just, these are how things are in random all caps and parts that are underlined and assertions of things that are not supported by any kind of citation. This Esquire is not helping him at all. Evidence of bias against Devine. Now we have yet again another completely new category, completely new section. Evidence of bias against Devine. If this is one of his arguments for error, this relates to the due process argument. So I don't know why he didn't just put this in his first paragraph instead of just dropping it in down here at the end. But I do know it's because he didn't edit any of this trash. He just kind of brain dumped it, vomited it out through his speech to text and printed it out and produced it as is with all of the, quotes in the wrong places and the Marty Riggs and the sentences that are not English and everything that he didn't bother to correct. The judge is not going to be pleased at your effort in presenting this piece of work to him. The entire 2022 IA report was drafted by a deeply biased and conflicted Deputy Chief Brian Holmes. Further, the bias of Brian Holmes against Robert Devine was known of and acknowledged by Chief McNamara and was ignored. The hearing officer addressed the issue of bias. Hearing officer said, yeah, don't think Holmes should have done this investigation. But at the end of the day, it didn't matter because it didn't affect any of the findings that were made. I don't see Devine acknowledging anywhere in this what the hearing officer actually decided. He's just reiterating his same argument that he made before and lost on. Holmes admitted to negative feelings toward Devine dating back to 2011 that continued to the present, and that he felt Devine would claim bias if he conducted the investigation, but stayed the course regardless of this fact. Chief McNamara was aware of a falling out between Devine and Chief Brian Holmes after the 2015 investigation. Chief McNamara testified that Brian Holmes had very strict feelings about adultery and that the 2014-15 involved adultery. In about 2016, there was an incident involving Devine's daughter. Yeah, we remember. His daughter was giving a trespass notice, preventing her from coming into the police station. And whose fault was that? Whose fault was that, Mr. Revenge is a dish best served cold? You threw her under the bus, and now you're complaining that she went under the wheels. The driving force for the investigation against Devine's daughter was Brian Holmes. Yeah, and why was that? Why you skipping some kind of important details and all that? Given the obvious bias, the entire 2022 IA report was unreliable and should not have been considered by the hearing officer. Boom, like no cases, not a single case about bias in a hearing in an investigator in an IA process. Nothing, not a single case that you could be bothered to go and find or take it out of a different context if you don't have one from IA, because yeah, we'll grant post is new. I don't know how much case law they have for whatever they had before they have post. Bias in the decision maker. I mean, whatever. Something. Come up with something so that there is some kind of articulable standard here for the court to apply, and not just, I say he's biased. Here's the things that are not the things that the hearing officer found, but are other things. And conclusion, he's biased, and therefore the entire report's out. Like, can't deal with the whole prejudice thing that the hearing officer dealt with in his decision, where he said basically, yeah, it would have been better if he hadn't been the investigator, but at the end of the day, it didn't matter. It didn't affect his decision. Don't really have a counter argument for that, do ya? Gotta just pretend it's not there. Conclusion. Devine statutory 55 CMR. That's a regulation. That's not statutory, but whatever. Devine statutory 555 CMR due process and constitutional rights were violated, and for the above reasons, the initial decision is not based on evidence that Devine engaged in a pattern of unprofessional conduct that may escalate. I'm sure that made sense to him when he wrote it, but it's just not a very good sentence. The Post Commission disregarded settled case law. Oh, there were like 2 that you cited in this entire opinion, and 2 of them that were like about criminal cases that don't even apply. Your cases about the criminal harassment statute, you're concerned that the Post Commission disregard. I can't imagine why they would disregard that. They disregarded settled case law and even their own published regulations. Which regulation? Which regulation? Because I'm pretty sure you cited only one, and that was the one about the evidence that they get to consider. And you never fleshed that out. You never established that there's, case law interpreting that, how that applies in the situation. You never showed situations where it met the standard, situations where it didn't meet the standard, so that we might be able to like sort out kind of what that means. You just said the IA report isn't something. You just said multi-layered hearsay and left it at that. At best, you argued one regulation. And here you are. Didn't you say that Sandra BIRCHMORE likes to exaggerate and embellish things? And here you are, pluralizing what you've done in your brief here. As well as entered evidence not presented at hearing in its final decision in order to rubber stamp a clearly slanted report due to nothing, all in one word, to nothing, more than public pressure. This is the first time we've heard anything about public pressure in all of this. Zero evidence of public pressure, and it's now just dumped into this conclusion out of nowhere. This is not meant to be like your last vomiting of every grievance that you have about this process. This is meant to be a summary of why the court should reach the conclusion that you want it to. And this is another place where it's really helpful to use that old word because, not a single because in this entire document. Not that I remember. If you guys found one, point it out to me. I don't think there's a single one in here. The decision does not provide clear and convincing evidence sufficient to decertify Robert Devine as a police officer. Signed with that Esquire, Robert Devine, pro se. Pro se. There it is. Remind him one more time. You're trying to put yourself on his level as a lawyer, trying to fluff yourself up in his courtroom, make you look more impressive than this complete piece of trash that you just filed in his court is going to give him any reason to think. January 12, 2026. The rest of this is just his, I served it. And then there's a copy of the final decision from the commission. Oh, that's our brief, guys. That's our brief. Man, this is just a flaming dumpster. Absolute trash heap. I mean, seen better writing than this from people who flunked out of law school after first year. It just completely misses the point. Doesn't even purport to ground itself in the legal standards that apply. And the very rare occasions that he actually brings up law, it's either law that has nothing to do with the situation at hand, or it's law that he just drops in and then doesn't provide any sort of analysis or context to explain how it applies to his situation. So thoroughly unimpressive piece of work. I don't know what the total process is here, like how exactly this is going to go. My expectation is that there's going to be some kind of response that's filed by the commission. We already know from the rule that there's supposed to be, a record that's prepared and transmitted up. The agency is supposed to do that, so I guess it will come when they file their response. So one of the, side effects of all of this is that everything that was done down there in the post division, they went to a lot of trouble to keep things hush hush, confidential, redacted a whole lot of different documents and stuff. Well, it's all going to be court record now. And it's not. I don't expect it's not going to get the same protection that it got down at that level. So we might have a whole big pile of information, a lot of which was, presumably sourced from the federal investigation that led to Matthew Farwell's arrest and prosecution out there in the public record for anybody to see. So I expect that they'll either file some kind of an answering brief, or they could. I don't really know the process. I mean, I would be tempted if this heap of trash landed on my desk and I was the person who's got to respond with it. I'll do what I need to do as far as filing the record, but I would consider something like, if it's allowed, I'm just going to file a motion to dismiss this on its face. It doesn't even purport to establish a basis for reversal. You can just kind of decide this on a summary basis, and you don't even need an answer from me. Like, go ahead and consider it unopposed, and it still doesn't provide you with any sort of basis to overturn it. But they're probably not going to do that. I mean, that is a little bit of a snotty way to handle it. And the answer is simply going to be, somebody needs to do the work for the judge. Devine couldn't be bothered to do it, which is not going to please the judge. So the post commission will do that. They'll provide him with the legal standard and, give him some kind of brief analysis about how the complaint here doesn't even come close to meeting the standards for reversal. So we'll just keep our eyes open for that, since Mr. Devine seems to want to keep this process going. Just can't let it go. We knew he can't let it go. We said from day one, he's gonna insist on this his entire life. Never going to acknowledge any kind of wrongdoing. He's going to deny as long as he draws breath. And yeah, I think there might be a realistic possibility that he is concerned about that law license. And he should be. Might not have been the smartest thing to call attention to it there in his little signature, his Esquire, because if the judge is displeased enough, it might be the judge who decides, what, I'm going to go ahead and refer this over, because nothing of value is lost if this guy's bar license is yoinked along with his police certification. So with that, guys, thank you for tolerating the slog through that absolute nonsense pile of words that we made our way through. I will keep my eyes open for any new developments. I want to give a special thanks, of course, and shout out to our good friend Dee Special Sauce over there on X. She's the one who got this document. She is the go-to source for the legal documents out of Massachusetts. So thank you so much, Dee, for getting that for us. And if more documents from this process come down the pike, we'll go ahead and take a look at them as well. But at the end of the day, I don't think we got anything to be concerned about in terms of the viability of this decertification hearing withstanding this challenge. This is like, a sword fight is going on in the appellate court, and like he's over here like throwing a frisbee in the other direction. Like this is not even in the universe of a credible appeal. And I'd be kind of surprised if it gets more than just a passing look by the judge and a toss to the side. Okay, clerk, go ahead and take care of that mess for me. So guys, until there is a new document, something else to go through, decision, brief, something like that, we'll just hang out and see how this one goes. But in the meantime, don't think we need to be real concerned that Mr. Devine is going to be a cop again in Massachusetts anytime soon. So with that, guys, thank you very much for joining me. I will see you next time.